Esteemed Professor, Dr. S. Please maintain silence.
Kindly stand up.
जज तो देखो.
वही मैंने देखा.
Good afternoon, one and all present here. I, Ms. Samruddhi Milintiwatne, student of 5th year BLS LLB at Janardan Bhagat Shikshan Prasarak Sanstha's Bhagubai Changu Thakur College of Law, welcomes our esteemed guests and everyone present over here for this third day of late Shri Janardan Bhagat Memorial Lecture Series with Justice Pradeep Deshmukh Sir, formal Judge, High Court, Bombay. As we have already inaugurated the lecture series on 27 January 2024 with the great presence of Advocate Mr. Dilip Shinde Sir, Senior Advocate of Bombay High Court on topic Criminal Justice System in India. The second day lecture was headed by Advocate Gajanan Chauhan Sir on topic Bail Application on 29 Jan 2024. Before commencing with our program, with due respect, I would request you all to please stand up for the national anthem.
तव शुभ नामे जागे, तव शुभ आशीष मागे, गाए तव जय गाथा, जन गण मंगल दायक जय हे भारत भाग्य विधाता, जय हे जय हे जय हे जय 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 हे।
भारत माता की जय।
I may request to please be steady for Maharashtra Geet. respect to our esteemed founders and guiding lights, late Shri Janardan Bhagat Sahib, late Shri Changu Kana Thakur Sahib, and late Shri Mato Shri Bhagubai Changu Thakur. I request our guest of honor, Justice Pradeep Deshmukh sir and Dr. S.T. Gardes sir, Mrs. Varsha Prashant Thakur ma'am, and our principal, Mrs. Sanvi Deshmukh ma'am, to proceed and play the flowers tribute and light the lamp which symbolizes the discipline of darkness and illumination of the knowledge.
या शुभ्रवस्त्रावृता या वीणावरदण्डवण्डितकरा या श्वेतपद्मासना या ब्रह्माच्युतशङ्कर प्रभृतिः देवैः सदा वन्दिता सा मां पातु सरस्वती भगवती निःशेषजाड्यापहा तेन्दुतुषा
Dear students, please join us to welcome today's guest, Dr. S.T. Gardes sir, Secretary and backbone of JBSP Sanstha. I may request our principal ma'am to welcome with sapling. S.T. Gardes sir is the former principal of Changu Kana Thakur Arts, Commerce and Science College, New Panvel, President, University of Mumbai College, Principals Association, Mumbai, Member Executive Committee, Principals Federation, Maharashtra State, Dean, Faculty of Commerce, University of Mumbai, Convener, Local Inquiry Committee for affiliation of academic programs at different colleges, and much more. His continuous support and valuable guidance is always inspiration. I request Dr. S.T. Gardes sir, Secretary of JBSP Sanstha, to welcome our today's guest of honor, Justice Pradeep Deshmukh sir, with a memento, shawl and sapling.
That too, madam, the tools make you feel like a guest. And then all these formalities.
Thank you, sir. I may request our principal ma'am to welcome Mrs. Varsha Prashant Thakur ma'am, an active and supportive member of JBSP Sanstha. Thank you, ma'am. Now, to embark the Janardan Bhagat Memorial Lecture Series, let's bring to audience another piece of verse that reflects the contribution of late Shri Janardan Bhagat Sahib in the field of education. For this, I would like to call upon stage Ms. Prerna Gaikwad, student of 4th year BLS LLB, to share the same with all of us.
नमस्कार आणि शुभप्रभात. मंचावर उपस्थित सर्व मान्यवर, प्राध्यापक आणि विद्यार्थी मित्र, दिनांक 27 फेब्रुवारी 2024 पासून आपल्या विधी महाविद्यालयाने स्वर्गीय जनार्दन भगत साहेबांच्या जयंतीनिमित्त द लेट श्री जनार्दन भगत मेमोरियल लेक्चर सिरीज आयोजित केली आहे. या प्रसंगी जनार्दन भगत साहेबांच्या आयुष्यातील काही अविस्मरणीय आठवणीतून त्यांची दूरदृष्टी आणि समाजसूचकता दिसून येते. या प्रसंगी त्यांची एक आठवण प्रकर्षाने आठवते, ती म्हणजे साहेबांच्या जीवनावर आधारित कर्मयोगी या पुस्तकातील एक प्रसंग. प्रसंगाचे नाव आहे प्रगतिशील शेतकरी. अंबाजी भगत गेल्यानंतर दुकानदारी व शेती अशा दोन व्यवसायाकडे लक्ष पुरवण्याचं काम भगत साहेबांकडे आलं. अंथरूण सोडताच भगत साहेब शेतीकडे चालू लागायचे. एखादं दातवण तोडून दात घासीत घासीत बांधावरून पाहणी करत फिरायचे. शेतीवरून फेरफटका करून घरी परतल्यानंतर आंघोळ करून सहकार्याच्या भेटीसाठी सुरू व्हायच्या चहा पाणी अगर न्याहारी असा शेतकऱ्यांचा रिवाज होता. जनार्दनानेही तोच रिवाज सुरू केला. 1955 साली तायचुंग ही जात उत्पादन देणारी भाताची जात आपल्या देशात काही ठिकाणी लावण्यात आली. पनवेल येथील श्री खतीब शेठ हे नव्या शेती उत्पादनात रस घेणारे होते. त्यांनी तायचुंग भात जातीचं बियाण मिळवून त्याचं रोप तयार केलं. भगत साहेबांना समजताच त्यांनी काही रोप आणून आपल्या शेतात लागवड केली. कोठे पनवेल आणि कोठे शेलगर पायी जाऊन यायचं म्हणजे 6 तास लागणार. पण भगत साहेबांच्या कार्यात अंतराला स्थानच नव्हतं. भगत साहेबांनी या विभागातल्या शेतीमध्ये अनेक वेगवेगळ्या पद्धती आणून उत्पादन वाढवलं. 1950 सालापूर्वी खुंटी कलम ही पद्धत सर्वांनाच नवीन होती. त्याला ही पद्धत माहीत होती. तो क्षेत्रातला फार मोठा जाणकार समजला जात असे. भगत साहेबांच्या शेतात एक गावठी आंब्याचं झाड होतं. भगत साहेबांनी खुंटी कलमाच्या पद्धतीनुसार त्या झाडावर प्रयोग केला. पहिलाच प्रयोग यशस्वी देखील झाला. आपण एक नवा प्रयोग केला आणि त्यात यश मिळालं याचं भगत साहेबांना समाधान होतं. कलमी आंब्याचं झाड असणं हे शेठ सावकारांची मिराजदारी ठरलेली असायची. पण कित्येक पिढ्यांचा रिवाज हा भगत साहेबांनी मात्र मोडून काढला. त्यानंतर त्या विभागात अनेक ठिकाणी कलमी आंब्याची झाडं लावण्यात आली. 1962 साली भगत जिल्हा परिषदेचे सदस्य झाले. कृषी समितीचे सदस्य असताना जिल्ह्यातील खाजगी व शासकीय शेती केंद्रे पाहण्याची त्यांना संधी मिळाली. शेती व्यवसायासोबत कोई कलमे करण्याचा जोड व्यवसाय सुरू करावा म्हणून शेतकऱ्यांनी अनेक खुंटी कलमे तयार केली. शेतकरी संघाने केलेल्या कार्याची पाहणी करावी असा प्रस्ताव जिल्हा परिषदेकडे पाठवण्यात आला. त्यावेळी जिल्हा परिषदेच्या कृषी समितीचे भगत साहेब सदस्य होते. कृषी समितीने त्या विभागात पाऊल ठेवलं. त्या क्षणापासून सदस्यपद बाजूला सारून जनार्दन भगत साहेबांनी भात शेती, फळबागायत, कोई कलमांच्या रोपवाटिका यांची माहिती कृषी समितीला दिली. एवढंच नाही तर आपल्या विभागातल्या अनेक प्रकल्पाची माहिती दिली. समितीकडून शेतकऱ्यांना मदत मिळावी म्हणून भगत साहेबांनी शेवटपर्यंत प्रयत्न सुरू ठेवले. रासायनिक खतामुळे सुरुवातीला फायदा होत असला तरी नंतर मातीवर दुष्परिणाम होऊन ती खारट बनत जाते व कमी उत्पादन देऊ लागते. नैसर्गिक खताचा वापर केल्याशिवाय जमिनीचा कस पूर्ववत होणार नाही हे सर्वांनाच कळून आलं होतं. नेमकं त्याच वेळी शेवाळीच्या खताचं तंत्र उदयास आलं होतं. तमिळनाडू राज्यातील अड्यार येथे या तंत्राचं प्रात्यक्षिक होतं. तेथे जाणं हे फार खर्चाचं व दगदगीचं होतं. या तंत्राचा वापर करून फायदा होत असेल तर त्यासाठी खर्च व त्रास सोसण्याची तयारी उपसभापती या नेत्याने भगत साहेबांनी दाखवली. त्यांनी ते संशोधन केंद्र पाहिलं. त्या तंत्राचा भगत साहेबांनी वापर करून पाहिला. कसंही करून आपल्या विभागात शेतीचं उत्पन्न वाढावं याकरता ते शेवटपर्यंत प्रयत्न करीत राहिले. राजकारणाचा व्याप वाढला तरी वेळ मिळेल तेव्हा आपल्या काळ्या आईशी ते हितगुज करीत. तिच्यासाठी झिजत राहून अखेरचा श्वास तिच्याच कुशीत घेण्याची जनार्दन भगत साहेबांची इच्छा होती. त्यांचा मृत्यू अकाली होता हे विसरून चालणार नाही. त्यांच्या अकाली मृत्यूची ही काही कारणं शोधली जात आहेत. त्यात शासनानं केलेलं भूमीचं बळजबरी हस्तांतर हे एक कारण आहे. भगत साहेब म्हणतात, माझा देह तुझ्या करता पडो असं अनेक नेते म्हणतात. माझा देह तुझ्या करता पडो असे अनेक नेते म्हणतात. पण भगत साहेबांनी या विभागातल्या भूमीकरिता आपला देह चंदनाप्रमाणे झिजवला. हे शेवटी भूमी करताच प्राण टाकले. शेती विना शेतकरी म्हणजे आई विना पोट असं त्यांना वाटायचं. काही लोकांना खूप पैसे मिळाले तेव्हा त्यांचं आपल्या मातेकडे दुर्लक्ष झालं. हे दुःख जनार्दन भक्तांना शेवटपर्यंत होत राहिलं. जमिनीपासून मिळालेला पैसा जमिनी करता खर्च केला तर ती भगत साहेबांना मोठी श्रद्धांजली ठरेल असं आम्हाला वाटतं. धन्यवाद.
Thank you, Prerna. I may request Shri Gardes sir to kindly address the audience.
So, good afternoon. Lovely, good afternoon. Thank you very much. Honorable former Justice Deshmukh Sahib, Honorable Varsha Thakur Madam, the member of the Board of Executives of our Janardan Bhagat Shikshan Prasarak Sanstha, Principal Deshmukh, the principal of our Bhagubai Changu Thakur College-of-Law, the faculty of our prestigious institution, and very important is the participants, dear students. First of all, on behalf of our Janardan Bhagat Shikshan Prasarak Sanstha, I would like to congratulate all of you and congratulate the college and college administration for organizing this very important and you can say that valid program in order to give something or some you can say that information, important information to the students about our great Janardan Bhagat Sahib. Janardan Bhagat Sahib, the name after whom our institution has been named, is the very important personality which influenced to our honorable chairman Ramsey Thakur Sahib, who is the chairman and you can say that pillar of our institution because he is the person who motivated him to become an entrepreneur, to become a person who can work in future in the field of education. And today, friends, our institution is one of the biggest institutions in our Panvel area, where around about 20,000 students are studying from junior KG to PhD, having this legal education, which is one of the best possible education in our country, necessary for not only for employment, not only for practice, but for the purpose of overall development of the students. I personally feel that every citizen, I am using the word citizen, every citizen of this country must know the laws of the, you can say that land. And that's why there is a necessity to understand first and get the knowledge about the variety of laws which are enacted previously and amended time to time for the purpose of its implementation and execution to the people as well as creation of the environment among the society. Friends, today we are in the 21st century. There are many challenges to the educational institution, challenges to the students, challenges to the citizens, challenges to the industry and every field. But our institution is working so hard, not only to survive, but to grow and have services to the, you can say that, parents and general people of this area to provide the quality education. You can say that schools affiliated to the state board, schools which are affiliated to the CBSE board and the colleges affiliated to University of Mumbai, our Sangukara Thakur Arts, Commerce, Science College, one of the best colleges of University of Mumbai, accredited with A+ grade and considered to be one of the strong institutions of this area. Our Ramsey Thakur College of Commerce and Science, Kharghar, new but very dedicated institution providing the educational facilities to the students of the Kharghar area, and this institution providing the legal education. Friends, our Panvel area is ever increasing, you can say that expanding because of the urbanization, because of the industrialization, because of the, you can say that, variety and many people who are coming not only from the different places of our Maharashtra, but from our country, even from the overseas. And that's why there are many challenges to the residents of this area. That challenges may relate to the legal difficulties and legal problems. For that purpose, our institution, you can say that, considered that establishment of the law college is very important for the purpose of the students of this area. And that's why our institution has been established, and I am happy that our law college is doing the best. Law college is doing the best. Only my concern is, remember, I am also the law graduate, but non-practicing, working as an administration in education. My concern is law learning of the legal language, learning of the laws is not merely reading the books, not merely accessing the, you can say that, internet, or accessing the, you can say that, programs on the online. It requires the continuous, consistent dialogue and the relation between the students and teachers. No excuse at all. And that's why attendance is very important. My concern is attendance. Negligence of attendance by students and negligence of attendance in the class by teachers is, you can say that, primarily concern. Today's, you can say that, subject is what? Criminology. That is the crime. Absenteeism in the class and negligence of that absenteeism by the teacher and institution is the crime. I personally feel it may be wrong in your perspective, but you will remember, as and when you will get your degree, you will feel that it is inadequate, because merely paper qualification is not sufficient. It requires the full-fledged personality of that particular individual to be a lawyer, to be a graduate in the law, to be a postgraduate in the law. Merely the knowledge or reading of the law is not sufficient. And for that purpose, basic jurisprudence, basic philosophy of the law is required to be inculcated in the personality. And that can be only earned in the classes by the interactive sessions like this. And that's why I congratulate to the college that you have organized such type of interactive session by inviting very rich people in the field. And today I am happy that the former judge of our Bombay High Court is here by sparing his valuable time by traveling hours to this New Bombay just for the purpose of sake of you students. And that's why I appeal to all of you, get the spirit and get the meaning of each and every statement which he will proclaim or which he will deliver to you for the purpose of your betterment. You will remember this in the whole life of your, you can say that, working life, that such and such lecture you have attended when you were in the Bhagubai Changu Thakur College-of-Law. Once again, I thanks all of you and wish the best academic career in your life. Thank you.
Thank you, sir. Students, the world is full of diamonds and gems. We are blessed to have one of it between us to build this lecture with the topic Evaluation of Evidence in Criminal Trial. To know more about this genius personality, I would invite Assistant Professor Anam Mahendikar ma'am to give a brief introduction about sir.
Good afternoon all, the dignitaries present on the dais and all the students present in the seminar hall. I, Assistant Professor Anam Mahendikar, would like to have a pleasure to introduce our today's resource person. We have with us former Justice Pradeep Deshmukh sir. Sir, born on 11 February 1958, graduated from Nagpur University. Sir completed his LLB from Nagpur University. Sir was enrolled with Bar Council of Maharashtra and Goa in 1981. Sir practiced as an advocate from 1981 to 1997 in criminal, civil side and labor and industrial court in original as well as appellate side. Sir appointed as legal advisor for various corporations, government departments and nationalized banks. Sir served as a lecturer in Dr. Punjabrao Deshmukh College-of-Law, Amravati from 1988 to 1996. Sir was appointed as a judge, City Civil and Sessions Court for Greater Bombay in 1997. Sir was posted at Joint District and Sessions Judge, Thane in December 1997 up to November 1999. Sir was posted as a judge of City Civil and Sessions Court, Greater Bombay in the year December 1999 and presided over criminal and civil courts having various matters for and against central and state government, MTNL, BMC, etc. Sir was notified as a special judge since March 2002 under Prevention Corruption Act 1988 and Narcotics Drug Substance Act 1985. Sir was appointed as a special judge for 1993 Bombay riots cases. Sir posted as a principal district and session judge Latur from 2008 till 2011. Sir was also posted as a member secretary, Maharashtra State Legal Service Authorities, High Court Bombay, and as a secretary, High Court Legal Service Authorities from 2011 up to 2013. Sir elevated as a judge of Bombay High Court on 2013. Thank you, sir, for your valuable presence. Now I take over Samruddhi to take over the dais for the further event. Thank you.
Without wasting this valuable time, I may request today's resource person, Justice Pradeep Deshmukh sir, to take over the dais and deliver the session. Also, I request the dignitaries to take the respective seats in front of the dais.
You are something. You want to contact me on 27th. Then what happened? So good. I hope you are here. The entire dais has gone. I can assure, mic वगैरह शुरू है ना. You are comfortable in Marathi, English, Hindi, Gujarati, in which language? Marathi. So, but then as a lawyer, you must argue in English. You must stand before the court, open your subjects in English. So we'll have both English and Marathi. So Madam has made my speech a little shorter. I can only now welcome my favorite students. Entire dais is already not there. Okay. First thing, I congratulate you for selecting law as your profession. Hopefully, you will all be going to law profession. Not that after becoming law, you will not practice. Girls, even if you get married, see that you are going to courts and practicing. Don't forget. Those days have gone when 30 years before, girls used to take admissions to law colleges as they were in the queue for getting married or getting married. So now those days are not. Now by choice you are taking your courses like law, medical, engineering, everything. Now instead of wasting much time in giving you a lecture on other things, I think I should come to the topic. Madam wanted me to speak on a specific subject, but I said law is such a vast subject. Instead of giving one particular subject to you to print in the invitation and to restrict myself on that, I said I will have interaction with the law students. Here, I think all students from all the years are present here, from first year till final year. So that is all good. Now, see, the subject now which I am supposed to speak is evaluation of evidence in criminal trial. Correct? So there are two types of trial, civil and criminal. Civil is like mathematics. 1 + 1 is equal to 2. So there is no other answer to that. But in criminal side, it can't be 1 + 1 is equal to 2 alone, because there is criminal law which is put into motion the moment the trial is on. So that can be 1 + 1, 3, 4, 5 or 0 also. So keep it in mind that what is decided by one court can't be the same judgment in the appellate court. That is why, suppose one is acquitted by the sessions court, there can be conviction by the high court. Recently, while I was presiding court, it was a case from Yavotma district. ते हे म्हणतात ना त्याला नरबळीची केस, सॅक्रिफायसिंग, मूल होत नाही म्हणून नरबळी दिली आणि 9 जणांना फाशीची शिक्षा झाली होती. and their appeal was pending before High Court for not less than 5 years. Out of them, 6 were men, 3 were ladies. So every day in the jail, ते विचार करत असतील आपल्याला फाशी झाली आज ना उद्या आपल्याला मरणार आपण वगैरे. But when I think I am audible to all. Is it? Yeah. But then when the appeal was opened, when we studied the case, we found that there was absolutely no evidence to convict, and that too to hang till death. That was the judgment by the trial court. Because the entire evidence was on section 27. Section 27 you must have studied by now in Evidence Act. That is a memorandum statement of accused. And that itself is not admissible in law because that is recorded by the police officer. You should keep the things in mind what we speak. Section 27 of Evidence Act. What is that? It is a statement to accuse. So that is hit by section 27 of the Evidence Act. You should the bus don't stand here and you come out of the fort. So that section 27 says that whatever statement is made to police is not admissible. So the conviction which was based by the trial court, that was Sessions Court somewhere in Yavatma, that has convicted them only on their statement, in which they say we wanted to have one child to one of their female in the family, and some Guruji, somebody told that for that they have to sacrifice some girl less than 5 years old. So they just picked one girl from one village, they killed her and they disposed of her body and everything. That was the theme. So one day one farmer found some small clothes, some frock, this, that, lying in his field. And then he complained it to police. Then police came. They seized all that material. There were also some traces of body parts, burnt. And then how the investigation proceeded. But without wasting much time on that, I will just tell you that this was done by the police before the memorandum statement of accused was recorded. That is under section 27. So this fact was already to the knowledge of the investigating agents because they have already seized it. So the statement then recorded after arresting out of 9, 2, 3, 4 somewhere arrested, and when they said we killed one girl and we destroyed her dead body at this place and threw her clothes at this farm, that was all not admissible because this fact was already to the notice of the police. This is how section 27 says statement made to police is not admissible. And unfortunately, the judge, relying upon all these section 27 statements, convicted, said death. So they were acquitted. So evaluation evidence is this. For that, you have to be thorough in not only in IPC, CRPC, but also in Evidence Act, and must have lots of knowledge. Knowledge in the sense by way of practical experience. Practical experience means to attend the court, attend the trials. I had started my practice in 1981, and by the time I joined in the year 97 in the City Civil Court, Bombay, I had conducted not less than 200 plus trials. But I still wanted to join judiciary because after working as a lawyer for a long time, somewhere you feel that you should do some social justice. This is all social work. Lawyers are paid very highly as against the judges. But now the judges are also, their pay scales are also good. It is not that I am discouraging you to not to go in judiciary. You should also become judges. But before that, you should have a long practice on trial side. Don't jump into the high court. I see nowadays lawyers, they become law, they do law, they go to high court. Then since they have not practiced on trial side, they don't understand what is what, which I am going to tell you today. Okay. So see, now for a criminal trial, it is just like a movie. You must be having smart TVs in your house, so many Netflix, and so many other channels. You must be watching so many criminal based terror movies and channel and shorts movies on that. It is just like that. You consider a criminal trial is a movie. Police officials are the script writer. Prosecutors, after the movie is done, is a director. How he is into the court hall, he will bring it in the court. And I don't say judge, but the public in general will say if the movie is correct or not. With this media behind nowadays, it is not a judgment of a judge alone, but even we deliver the judgment before that, media is already giving their opinions as to what is not. So we don't say that alone judge is responsible or can said to be the deciding factor, but the entire public at large can be in the seat of a judge to decide whether this is correct or incorrect. So now, for a criminal trial, what is important? What has to be there? Hmm. You must have seen Hindi movie Talash. Who was there? Amir Khan. Okay, whosoever it is. So there is one incident. You must be remembering that incident. So it starts with that incident. So any criminal trial, for having any criminal trial, there has to be incident. Without that, nothing can proceed ahead. Say, for instance, there is a murder in some chalk in Panvel. So that is an incident, of which report is given to police. So what has come into force immediately after the incident took place? IPC. तुमच्या डोक्यात सगळ्यांच्या लागले असेल 302 झाला है ना 302 झालं ना मनात काय आलं पण दॅट इज इनकरेक्ट 302 केव्हा येणार जेव्हा त्याच्या विरुद्धचा ऑफेन्स प्रूव्ह होणार तेव्हा आता काय झाला 300 झाला 300 section 300 how many of you have learned IPC please raise the hand IPC only you alone no you can tell I am not asking you any questions just tell me how many of you have learned IPC yeah I have and I know in law college you don't understand anything even I was not knowing anything त्याच्यामुळे आजच मी तुमची परीक्षा घ्यायला आलेलो नाही पण I will definitely see that once you come into practice you should not have these problems मर्डर झालं की सगळे म्हणतात 302 च्या घटना 302 is somebody is teaching punishments also I have seen in here there some ladies giving a lecture on that penology last day so this 302 is what is the penal action against it when that can be done only when 300 is proved so what has happened murder happens means section 300 should be in your mind not 302 now incident took place report so what will come into picture now CRPC I was just telling madam there's these subjects should be taught together in 1 year IPC CRPC and evidence unfortunately we have these 3 subjects in 3 years so now what came into picture after 154 police will come on the spot now this is now again criminal procedure is going on police will go to the spot सबसे पहले पुलिस का काम क्या है वहां पे जाके when the dead body is there and the most important investigation part of investigation is inquest panchana have you heard of that yes what is that that is the finding of external injuries on the person of the body that is a homicidal death what is homicidal death killing of human being by a human simple language killing of a human by a human being that is a homicidal death now there has to be injuries otherwise there can't be any death at instances there can be death without having any external injuries but then this panchanama shows what are the injuries which are sustained by the deceased maybe superficial semi-superficial internal injuries but then they can write in that no injury found that is why the body is sent for post-mortem then the external injuries found on inquest are tallied with the post-mortem injuries so they are anti-mortem and post-mortem injuries. So which are ante-mortem, which are carried before the post-mortem is conducted, and naturally post-mortem injuries are after the post-mortem injuries. There is one more column after section, column 17, all external injuries are to be mentioned, and there is one column where there is a internal injuries. All this I am telling you, don't get bored, because you have to evaluate the evidence. So now what is there is one more column which states of internal injuries. Why these columns are necessary? Because you have to correlate external injury with the internal injury. Because doctor will give opinion as to the cause of death. The death has caused because of the brain hemorrhage, caused due to external injury, so and so. So if he is hit on head by a rod, there may not be any external injury, but this can have an internal injury to the brain or any other part of the head, and that can be the cause of death. So it comes again a case of 300. Correct? Don't say 302. This is a general layman's thing. 302. Now, after the PM is done, what is the best thing and the most important thing which is to be done by the police upon which the entire film is based? स्क्रिप्ट रायटिंग है ना. तुम्ही म्हणता ना पिक्चरचे डायलॉग खूप छान आहेत. काय आहे? कारण ते लिहिले चांगले आहेत, मग पिक्चर चालेल. तसंच पोलिसांनी जर स्टेटमेंट बरोबर रेकॉर्ड केले तर ती ट्रायल चांगली चालेल. आय एम कीपिंग यू ऑन द लाईन ऑफ अ फिल्म बिकॉज यू कॅन जस्ट हॅव दॅट आयडिया. आता पोलिसांचं स्टेटमेंट्स आर रेकॉर्डेड अंडर सेक्शन व्हॉट? सीआरपीसी अगेन. सीआरपीसी शिकले ना तुम्ही? सीआरपीसी नाही शिकले? नाही झालं सीआरपीसी नाही. Okay. So madam will take care to have all three together. The 161 of CRPC section says recording of statement by police. This I am telling you for information and for the purposes of today's subject. And 162 CRPC says what is the use of this statement recorded under 161. So what is the use and what is the purpose? This we will consider when we go ahead of our story, not at this stage. Because that would be one of the important aspects of evaluation of evidence. Now statements are recorded. Accused is named by somebody whose statement is recorded. He will be arrested. Then he will be produced for remand. That you must be knowing by reading in the papers. He is produced before the magistrate. Police asked for police custody. So remand provisions are again in the CRPC. Immediately after the arrest, within 24 hours, he is to be produced before the magistrate. Investigating agency will ask for police custody for the purposes of investigation, interrogation. And normally court will grant, because unless he is in the custody, how can there be any information from the accused? So after that phase is over, that is of 14 days. No court can grant custody to police exceeding 14 days. Law says he should not be in the custody of police for more than 14 days. No court will grant that. So he is then taken to judicial custody. Judicial custody means he is not released on bail, in the custody of the court. Initially he is in the custody of police. Now he is in the custody of the court. Within that span of 14 days, they must interrogate the accused. Then he is taken to judicial custody. If at all some more interrogation is necessary to be carried out, like in big cases of narcotic drugs, under your MOCA Act, the part of investigation is very lengthy. So with the permission of the court, again in the jail, they can be interrogated, they can be investigated in the presence of jailer. We are not going into that again. Now investigation is over. Statements are recorded. Panchanama is there. One more Panchanama is important, that is of a spot Panchanama, which is normally taken up as a very casual document. But it is very important document, about which also I will tell you later when we go to the evaluation. Now charge sheet is filed. Charge sheet is always filed before the concerned magistrate. Now, who is the concerned magistrate? Within whose jurisdiction incident took place, and who is the concerned police station again, within whose jurisdiction the incident took place. Now, that magistrate will secure presence of all the accused, and he will commit the case to sessions court, because it is a murder case and power to conduct a murder case is with the sessions court. So that will be committed to sessions court, and all the accused will be ordered to remain present on the next date before the sessions court. Now, pausing here, I will give you one incident. I was conducting one special case. I was special PP there appointed by state, and there were about 9 accused persons, and they used to very rigorously attend the court, knowing that there is no PP appointed. So naturally, they are going to get a date, and such thing went for about 2-3 years. Then I was appointed. They were not aware of this. So under legal advice, they must have been told that तुम्ही त्या हजर राहा, तारीख घ्या आणि या, कारण साहेब कोणी नाही आहे सरकारी वकील तर तुमची तारीखच होणार आहे. So now charge can be framed only in the presence of all the accused. But since they were not knowing I am appointed, and I went to the court and all of them were present, matter was called, all of them came in the court in the witness box, in the accused dock, and I gave the copy of draft charge along with my notification of appointment to the concerned judge. So judge was also very eager to frame charge because the trial was languishing for years together. So he said, "Chalo 1, 2, 3, 4, 9." एकेकाला बोलवलं आणि चार्ज फ्रेम केला. So they were shocked. They never knew that some PP will be coming and the charge will be framed today. But they were having their own legal advice to remain present, seek a date and go. That it didn't happen. Charge was framed. So this is how the stage of charge would come. Charge can be framed only when all the accused are there. Now after framing of charge, now there is a remedy to accused to go for discharge. So we are not going into that aspect today. And then matter will be fixed for recording of evidence. Now comes the important thing, examination in chief. This is how the sequence go up to the judgment. So examination in chief is based on 161 statement recorded by police. Now you go back to 161. That is the statement recorded by police. It is signed by the concerned police officer and not by the person making that statement. Why it is not signed? Because that is the statement which can be used for the purposes of contradiction and omissions only. How many of you know contradiction? And how many of you know omissions? For that you read Tahsildar Singh's judgment. It is of 1950s. 1950s, still holding good law and is relied by everyone up to the Supreme Court also. So what is a contradiction? Simply, even if you forget about a contradiction in a statement, but you can say what is contradiction. Even in general speaking, if you say he is making a contradictory statement, so you can understand what is what. Contradiction is something which is said at some time and now you are differing to the same statement. Similarly, what is omission? Omission is something which you have not said but has said in the court, so that they have omitted in their 161 statement. These are the two simple things, but these are very important things to evaluate the evidence to reach to the conclusion if the witness is speaking truth or he is a liar. This is how judges are not God. What you read, even we read the same thing. What statements are given to the lawyer's side are same documents are even given to my wife has given me 2 hankies today. I don't know why. So वाईफ म्हटलं की सगळं विसरून जाते पुढचं. कुठे होतं आपण? Contradiction. Yes, a contradiction. So same set is also provided to the court, whatever is given to the accused. So lawyers should know how these contradictions are to be brought on record, how these omissions are to be brought on record. For that purpose, only thing is that vast experience. Even if you go with your senior and you are watching the trial conducted by your senior, you will not understand. But when you will yourself conduct the trial, you will understand. How you will understand? You will keep that 161 statement before you. Witnesses in the witness box. You are a defense counsel. Chief will ask him according to the statement made. Now, what is mentioned in the statement is contradicted while giving oral evidence is a contradiction. So you will just record that contradiction. And when you are similarly, what is not mentioned here but is stated in the court, that is a omission, which can also be said as improvement, which is not in the statement and stated in the court is the omission. Now your turn comes as a cross examination. So what you will do, whatever instructions you are having, you will cross examine on that first. Now who will give the instructions? Accused will give the instructions. Thereafter, we will come to the most important aspect of the cross examination, which will establish if the witness is saying truth or he is speaking lie. That is your contradiction part. You will ask him, असं झालं का? You have to frame a question in a manner. In the cross examination, there is a very wide scope. In chief, you just can't put leading questions. But in cross, you can say anything which is relevant to the subject. You can ask him, सपोज आता तुमचा पनवेलचा जो इन्सिडेंट आपण सांगितला मर्डर तो सकाळी 11 वाजता झाला. अँड वन विटनेस इज सेइंग की मी तेव्हा लॉ कॉलेजला चाललो होतो आणि 11 वाजताची वेळ होती आणि तो म्हणतोय 11 वाजता मी जात असताना मी पाहिलं एनी बीला फायर केलं. दिस इज अ स्टेटमेंट. नाव ही इज कमिंग इन द कोर्ट अँड सेइंग की मी 9 वाजता येत होतो आणि आय सॉ द इन्सिडेंट, ही हॅड किल्ड बी बाय गनशॉट. आता काय तो इन्सिडेंट 9चा असेल परंतु त्यांनी सांगितलं 11. आता पोलीस दॅट इज हू द इन्व्हेस्टिगेटिंग एजन्सी दे मेड इम्प्रूव्हमेंट कॉन्ट्राडिक्टिंग दॅट ही शुड बी डिलाइट. 11 वाजता तो मर्डर झाला असते 9लाच झालं तर 11 वाजता ही कांट बी आय विटनेस. तर त्याला पोलीस सांगतात, पीपी सांगतात की यू से की 9 वाजता गेलो. नाव यू विल क्रॉस एक्झामिन की हे बघ तू सांगितलं 11 वाजता तू येत होता तेव्हा मर्डर बघितला, असं झालं का की तू 9 वाजता येत होता? आता तो कसं हो म्हणणार ना, कारण इन्सिडेंटच 9 वाजता झाला तर ही विल से येस. मग त्याला म्हणायचं की तुझं स्टेटमेंट घेतलं पोलिसने त्याच्यामध्ये तू किती वाजता सांगितलं तर तू म्हणाल 9 वाजता, कारण ही हॅज टू सपोर्ट द प्रॉसिक्युशन केस. तर तू म्हणाल की यू विल कन्फ्रंट हिम विथ हिज स्टेटमेंट, शो हिम हिज स्टेटमेंट. हे बघ याच्यामध्ये लिहिलाय तू 9 वाजता झाला नाही 11 वाजता झाला. देन ही विल से आहे आता इट इज देअर बट ही हॅज नॉट साइंड. Statement of witnesses are not obtained on the 161 statements. It is of the investigating officer. Correct? Now you will simply mark that portion as A, that bracketed portion. की मी 11 वाजता झाला असं लिहिलं. त्याला मग तुम्ही विचारणार, यू हॅव टू गिव्हन अन ऑपॉर्च्युनिटी टू एक्सप्लेन. मग इथं 11 कसं आहे, तू तर 9 वाजता म्हणतो तर मग 11 वाजता कसं काय लिहिलेलं आहे? So for that naturally you will say मला नाही माहित. Okay. But now this portion which is marked as A, that can't go on record unless it is exhibited. तुम्हाला एवढं बेसिक माहिती असेल की कुठलेही डॉक्युमेंट जोपर्यंत एक्झिबिट होत नाही तोपर्यंत कोर्ट कॅनॉट रीड दॅट. कोर्ट विल नेव्हर रीड इट. करेक्ट? Now who will prove this? The investigating officer, because he has signed it, he has recording this. मग जेव्हा आयोचा एव्हिडन्स येईल इन द विटनेस बॉक्स वेन ही विल बी देअर, ही विल आस्क हिम ड्युरिंग द इन्व्हेस्टिगेशन तुम्ही हे XYZचं स्टेटमेंट घेतलं? तो म्हणेल हो. त्यांनी तुम्हाला सांगितलं हे लिहिलेलं आहे बरोबर आहे का की 11 वाजता? तो म्हणेल हो, कारण त्याची सही आहे, ही कॅनॉट लाय. तो म्हणेल हो. मग तो जो ABCD तुम्ही, थँक्यू सो मच, हू इज डन दिस? Good. त्यांनी जो मार्क केलेला पोर्शन आहे ना, that will be exhibited. Earlier it was only marked as A. Yeah. Now very important thing is that we come across many lawyers, senior lawyers, they come for cross examination, and material cross examination is over, then they go to another court. Now you will be finding lawyers in Bombay, they will cross examine the eyewitnesses. Somebody will come only for cross examination of forensic experts. Some will come for cross examination of doctors. Some will expertise in every branch. But now the eyewitnesses incident is over. They will keep their junior, you attend and you will go to another court to examine another witness on cross examination. Now this junior is not expert. He is naturally a junior. So he will put some formal question thereafter and he will sit down. That evidence is over. Now what remained in this? That portion which was marked as A, that needs to be confronted. This that senior should have done, or at least have told the junior, that remains to be exhibited. So even if this witness is not speaking truth, but for incorrect cross-examination, since that is not brought on record, that evidence cannot be read by the court. That is why, what is the basis of criminal jurisprudence? Let 100 of guilty go scot-free, but not a single innocent should be punished. तुमचा एक झाला आहे क्रिमिनल ज्युरिस्प्रुडन्स, झाला आहे ना क्रिमिनल जस्टिस सिस्टम इन इंडिया. एक आहे मिस्टर अनिल, क्रिमिनल ज्युरिस्प्रुडन्स, दे विल टेल यू ऑन दॅट क्रिमिनल ज्युरिस्प्रुडन्स. आता बघा, सी द ब्युटी ऑफ लॉ. आता जजेस नो की हा विटनेस खोटं बोलतोय. तुम्ही बोर झाले का? नाही, आय थिंक यू आर गेटिंग बोर्ड. ओके, से समथिंग. विल फिनिश हाफ एन आवर. तर आय लॉस्ट माय लिंक. इज अ वेरी ब्युटी ऑफ लॉ इज when you evaluate the evidence. Now judges knowing this witness is speaking lie, but because of the fault investigation, faulty cross-examination, that portion is not true. Correct. So he has to read that तो 11 वाजता चालला होता, है ना. Same thing with omission. If something not mentioned in that and he is saying, so same procedure is to be adopted and take it on record. Now this is how the witness, though he is not reliable, court will have to rely upon it. Unlike the case which I had said, which was based on a memorandum statement of accused which are recorded under section 27 of the Evidence Act, which by law says it is not admissible. So even in the cross-examination, there is no suggestion put to the witnesses. His statement as these are not admissible in law. Court is not blind. Court has to see that that is a non-admissible evidence. But इथं काय, see the difference. Here also the evidence is non-admissible, but it is not brought on record. Now we, while sitting in appeal, can't go to the trial court. We can always remand the case, but not for removing the such loopholes. We can't remit back the case for removing the loopholes, and all the more for something which is against the accused. Article 21 of the Constitution says nothing can be done against the accused, because our criminal jurisprudence says prosecution has to prove its case beyond reasonable doubt. Even if there is the slightest doubt, it is to be given to the accused. As against this, accused is not supposed to prove his case beyond reasonable doubt, but he has to just take out the probability. नुसती शंका आणायची आहे त्याला रेकॉर्ड, not need to establish it beyond reasonable doubt. And if that can be done and it is reasonable, court has to give benefit of doubt. तुम्हाला बघितला जजमेंट येत असतील, तुम्ही वाचत असणार, ॲक्विटल, conviction किंवा acquittal by giving benefit of doubt. तर suppose it is a case of anti-corruption and accused is acquitted by giving him benefit of doubt, then it is not a clear acquittal. He cannot be reinstated to his service. But if it is a clear acquittal, then it is acquittal. आता याच्यामध्ये कसं झालं की त्या वकिलांच्या चुकीने इनकम्प्लीट क्रॉस एक्झामिनेशन झाल्यामुळे कोर्ट इज रिलाइंग अपॉन दॅट विटनेस. So court has to do this. आता बघा, I'll tell you one case. I was in city civil court that I can always say because my judgment was maintained by the High Court and also by the Supreme Court. And now the accused has already undergone 20 years of his conviction and he is now out of jail. He was a Parsi fellow, a pilot, and for more than 10 years he was taking Air India flight from Bombay to Delhi, London. And after a halt of whatever according to the rules, he was coming back from London to Mumbai. This is what was going on for last more than 10 years. Along with him, same purser, same that aerospaces, वगैरह staff, they have their fixed combination. So one day, one of his purser, he phoned him and told that Mr. So-and-so, I am unable to come on service today, but my daughter needs one empty bag. She was in England, so can you just carry the empty bag with you? So he said that time he was at his farmhouse nearby Panvel only. So he said, I am at my farmhouse, you leave the bag in my house. Maid is there, she knows you, and I will take the bag. He in the evening came home and he was informed that such and such bag has come. So he was traveling every day in and out. So he used to travel with a small bag with him overnight carrier. He took his small bag, he kept it in the bag which was brought by the purser. Why to carry two articles? So he took it, kept it there, put his name tag to it. His vehicle came at 2 o'clock. It must be a late night flight. He went to airport. He went there, checked in that baggage. Then he went in the cockpit and he was sitting. After 15-20 minutes, his name was announced. He was called to the check-in counter. And some officers from Air Intelligence Unit were there. And they came, they asked Mr. So-and-so, which is your bag? So he said, this one. You have checked in? Yes, I have checked in. No, see, he has admitted he has his own bag. He was taken to the office. They have already arranged for punch witnesses. So in their presence, he admitted. Now they were taken to the office where that bag was opened. There was his bag inside, and cocaine was concealed in the bigger bag in all of his sides and on the bottom. Now see, this was a clear-cut case of admission. Correct? So once the things are admitted, then there is no defense. And moreover, in anti-corruption as well as in narcotic drugs, of which this case was, there is a section which says presumption will arise. So when will presumption arise? When the accused is found in conscious possession of narcotic drug. Now he was found in conscious, he was consciously in possession. आता बघा त्याची केस अशी आहे, his case was this what I told. My purser brought a bag in good faith I was to carry. That is his case and very good case. But this presumption was coming against him. What it said? When the accused is found in conscious possession. The conscious म्हणजे unless he have at the totally unconscious is found possession, identifying bag, त्याच्यासमोर काढलं, कोकेन एवढं मोठं निघालं. So all this is law, how the evaluation is to be done. That is why we say not a single innocent be punished. But now here he is innocent. I was knowing he was innocent. कारण त्याची पूर्ण believe करण्यासारखी story आहे. But law was against him. So in such cases we have to not follow the jurisprudence, but the evidence only. This is how you must learn law. Now going further ahead, most important topic. We are now on. We are discussing murder's case. Now after the arguments, what is the stage which come arguments के बाद में, I mean before argument 313, that is statement of accused, and this is very important stage of trial, because till now accused is not supposed to speak single thing to the court, but through his lawyer only he can mention so many things. 313 is the only stage, that is statement of accused, where he can have direct dialogue with the court. In fact, court will put him questions in respect of all those evidence which has come against him, for which he has to give his explanation. की तुझ्या विरुद्ध असं असं याचं काय म्हणणं आहे असं. He will say no, 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 no. That is a different thing. And lastly, he can come out with his own case, in which he can state की असं नाही असं आहे. Now, to what extent that is to be relied, again, is a matter of evidence. For that purpose, he can examine defense witnesses. You know, there is a stage of defense witnesses which is after 313. And after 313, then arguments. And if the accused is found guilty, then he is to be heard on the point of sentence. त्याला किती punishment द्यायची. Here you have to hear. You must have read in papers few years before, one bus driver in Pune, he under the influence of liquor committed theft of an ST bus, and he drove it in Pune and killed many persons, and many accidents had also taken place. So that matter was naturally, trial was conducted in Pune. He was convicted. That appeal was before me in the High Court. But there I found that the trial judge had not heard that accused on the point of sentence. To hold guilty is one thing. आता तुझ्या विरुद्ध चार्ज जो फ्रेम केलाय तो प्रूफ झाला, पण आता तुला किती सजा द्यायची याच्यावर त्याला तुम्ही ऐकायला पाहिजे ना. दिस इज एंटायरली डिफरंट थिंग. He was not heard on that sentence. So I had to remand the case back to the trial court with directions to hear him, not a de novo trial. De novo trial त्यासाठी होत नाही. De novo trial means to entirely have a fresh trial with specific directions only to hear the accused on the point of sentence and to send the record back to him. So he was heard on the point of sentence. Again, the appeal was decided. This is how there are so many minor things. Nobody will tell you in law college. तुम्हाला सांगा, एवढं मी आता तुम्हाला बोर केलाय अर्धा पाऊण तासापासून, एवढं आजपर्यंत तुम्ही कॉलेजमध्ये कोणी सांगितलं का तुम्हाला? कारण हे पुस्तकात नाही. इट इज नॉट द, नाही नाही नाही, स्टाफची काही चूक नाही. बाय वॉचिंग द स्टाफ, दिस इज नॉट पार्ट ऑफ युअर कॅरिक्युलम. दॅट इज हां, प्रॅक्टिकल एक्सपिरियन्सेस. म्हणून मी म्हणतो की तुम्ही कॉलेजमध्ये या नका येऊ, पण कोर्टामध्ये जायला लागले की रेग्युलर. कारण आय वॉज ऑल्सो काय ना, नाही मी सगळं त्यांचा इंटरेस्टचं सांगणार आहे. कारण आय एम ऑलवेज हॅपी विथ द स्टुडंट्स. मी जज असताना सुद्धा मला बारमध्येच जायला आवडायचं हायकोर्टच्या, कारण तिथे बरेचसे कॉन्टेम्पररीज येते. अँड वी हॅव युअर ओन रिस्ट्रिक्शन्स. असं नाही की आपण गेलो की त्याच्यासोबत काय तिथे जेवत बसणार आहे आणि पत्ते खेळत बसणार आहे, बाकी जे वकील करतात तसं नाही. जाऊन गप्पा मारायचं 10 मिनिटं. यू कॅन हॅव टी कम. What is that? That is in fact a healthy sign of a bar and a bench. So when you start practice, you एक लक्षात ठेवायचं की एक तरी ट्रायल तुम्ही चार्ज सेशन्स ट्रायलचे स्टेज कुठले, फ्रेमिंग ऑफ चार्ज. हे अगोदरचं ते जाऊ द्या, रिमांड तिकडे नाही गेली तरी पण चार्ज फ्रेम झाला की मग प्रोग्राम देतो पीपी. या तारखेला हे विटनेस, या तारखेला हे विटनेस, या तारखेला हे विटनेस. सेशन्स कोर्टला जायचं, इथे पनवेलला आहे ना सेशन्स कोर्ट, किंवा आत्ता पण तुम्ही जाऊ शकता. नोबडी विल गो टू स्टॉप. यू कॅन से युअर लॉ कॉलेज स्टुडंट. जायचं, बसायचं आणि ते ट्रायल बघायची जजमेंट होईपर्यंत. असे तुम्ही जर ट्रायल केले ना अटेंड, तर तुम्ही लॉ कॉलेजमध्ये नाही आले तरी तुम्ही खूप चांगला पेपर लिहू शकाल. आता मॅडम परत मला आता म्हणतील, ऑफकोर्स ते करा. आमच्या कॉलेजमध्ये माझा स्वतःचा एक्सपिरियन्स आहे. आम्हाला एक प्रोफेसर शिकवायचे. ते शिकवायचे म्हणजे असं, हां, येस सेक्शन 302 ते वाचून टाकायचे 4 ओळी. नाव विल गो टू 303. कशाला पोरं बसणार आहे? वाय स्टुडंट्स विल सिट. मग त्यांना कंटाळा येतो सकाळी सकाळी उठून या आणि तिथं येऊन बोर व्हा, है ना. पण तुम्ही तसं नका करू. आमचं काय ना, मी मला मॅडमला सांगत होतो, आमचं स्वतःचं एज्युकेशन सोसायटी आहे. अँड माय फादर वॉज अ प्रिन्सिपल ऑफ लॉ कॉलेज फॉर मोर दॅन 34 years. तर मग बाय डिफॉल्ट आय वॉज व्हेरी लेट रायझर. सो ही वॉन्टेड मी टू गो अँड टेक लेक्चर्स इन लॉ कॉलेज. तर ते मला म्हणायचे यू मस्ट गो अँड टेक एंगेज लेक्चर्स. तर मी जायला लागलो. मग मला जरा शिकवायला आवडणं लागल्यापेक्षा मुलांना मी शिकवलेलं आवडायला लागलं. त्याच्यामुळे काय झालं, मग फर्स्ट इयर, सेकंड इयर, थर्ड इयरचे सगळे तिन्ही इयरचे स्टुडंट्स त्या सब्जेक्टचे माझाच क्लास अटेंड करायचे. मग ते बाकी स्टाफ मला म्हणायचे तुम्ही हा पिरियड घेता, आमच्याकडे आयपीसीला कोणीच येत नाही. तुम्ही म्हणतो ते माझ्याकडे येतात. म्हणजे फर्स्ट इयर. मग आता काय, काही स्टुडंट्स अशी असतात की ते नाही, मी फर्स्ट इयर ए सेक्शनचा आहे तर मी बीला नाही जाणार. दॅट इज ऑल्सो गुड. आय वॉज नवर इन्सिस्टिंग, बट आय वॉज टेकिंग हुअर इज कमिंग, आय वॉज वेलकमिंग. And I other way taught for more than 10 years. पण मी सांगतो की आय हॅड नेव्हर बीन टू लॉ कॉलेज टू आस्क फॉर आय विल टीच दिस सब्जेक्ट ऑर दॅट सब्जेक्ट. कारण जसं कॉलेज उघडणार तेव्हा स्टाफची कुठला सब्जेक्ट घ्यायचा यासाठी जरा ओढताण होत असते. मी म्हणायचो जो राहिला तो मी शिकवेल. हा, त्याच्यामुळे काय व्हायचं की माझे सगळे लॉ वाचून व्हायचे. अदरवाईज ॲज अ लॉयर तुम्ही टेनन्सी लॉस तुम्ही वाचले का, लेबर लॉस तुम्ही वाचले का? नाही वाचणार तुम्ही, हे की नाही, अनलेस यू आर रिक्वायर्ड. आणि लॉ कॉलेजमध्ये कसं यू आर आय थिंक आर ऑल स्मॉल, बट बँक मॅनेजर्स, गव्हर्नमेंट सर्व्हिस मधले लोक वगैरे पण येतात. तर 45 मिनिट्स तुम्ही म्हणजे 10-15 मिनिटं यू कॅन पोखात आण, नॉट फॉर 45 मिनिट्स. फॉर दॅट यू हॅव टू रीड, irrespective of any subject, you have to read that. है की नाही? त्याच्यामुळे आय यूज टू टीच ज्युरिस्प्रुडन्स, कॉन्स्टिट्यूशन, all subjects, and my favorite were criminal side subject, and this is how I landed in criminal side court. And my assignments were all the time on criminal side, bails and appeals and criminal appeals, everything. Now we are coming to the most important aspect of the evaluation of evidence. This is section 299 and section 300 of IPC. Now see, there is a thin line of difference between these two sections. मग आम्ही सांगितल्याप्रमाणे 302 is not murder. Murder is 300. Now what is 299? Culpable homicide not amounting to murder. Now section 299 and 300 is to be read together with section 304 part 1, 304 part 2. Now what is that? 304 part 1 is punishment for culpable homicide not amounting to murder, and that is for life or up to 10 years or to 10 years. तुम्ही लक्षात ठेवा, if you read the things na, you will not understand. If it is explained and then you read, तर तुम्हाला लक्षात राहिलं तर राहील. 304 part 1 is life and punishment to 10 years. To 10 years म्हणजे not less than 10 years. Has to be 10 or life. And 304 part 2 is up to 10 years. So there is no life. Only up to 10 years. Now why this differentiation of 304 part 1 and 2 in punishment? And when this will arise? This issue or this question will arise for the purposes of argument and for the court to decide only after the trial is complete. Understood? Because whether the case falls in the category of 300 or 299, murder ahe ki culpable homicide hai, and for that you have to evaluate the evidence. Correct? For आजकाल पोलीस लोक 304 पार्ट 2 खाली ऑफेन्स रजिस्टर करायला लागले, FIR. In many of my criminal writ jurisdiction, I have sent copies to CP asking for their explanation how there can be an offense under 304 part 2. You can ask, you can go for 304A, B जे आहे ना त्याच्या खाली, not in the 304 part 1 and 2, because 304 part 1 and 2 will arise only after the trial and after the arguments, and only in the cases of murder, not घराचं बांधकाम सुरू आहे आणि स्लॅब पडली मजूर मेले तर 304 पार्ट 2 होणार आहे का? पण पोलीस आर अप्लाइंग दॅट. एका केसमध्ये महाबळेश्वरून एक टॅक्सीत दोघं माणसं चालले होते. वन बाईक वॉज कमिंग फ्रॉम द अपोजिट डायरेक्शन इन दॅट घाट अँड इट वॉज अन ॲक्सिडेंट. बोथ ऑफ देम डाईड. पोलीस रजिस्टर्ड ऑफेन्स ऑफ 304 पार्ट 2. आता काय त्यांचं इंटेन्शन होतं मारायचं ते काय, बरं ऑल द वे ड्रायव्हरच्या विरुद्ध केलं तर ठीक आहे. इवन अगेन्स्ट दोज 2 ऑक्युपंट्स ऑफ द व्हेकल हु आर सिटिंग इन द बॅक. दिस इज हाऊ द थिंग्स आर गोइंग ऑन. त्याच्यासाठी यू हॅव टू हॅव गुड लॉयर्स अँड फॉर बिकमिंग अ गुड लॉयर युअर क्रिमिनल नोशन्स शुड बी व्हेरी क्लिअर. नाउ हाऊ यू विल डिफरन्शिएट इन 299 and 300? There are two simple things, but many lawyers even don't know that how the case is under 299 or 300. Now section 299 says when the punishment under 3041 is to be given, you have to see whether there is intention and then knowledge, and in part 2 you have to see whether there is a knowledge and intention, असं vice versa. आता 300 आपण जे म्हणतो मर्डर, त्याच्यामध्ये यू हॅव टू सी ओनली इंटेन्शन. समजा एखाद्याला मर्डर करायचा आहे तर तो आता प्लॅन करून जाईल. ह्या 11 वाजता इथे येतो, 11:30 पर्यंत इथे असतो, तो गन घेऊन जाईल, रॉड घेऊन जाईल, काहीतरी घेऊन जाईल ज्याने इन्स्ट्रुमेंट विच इज डेंजरस, फॅटल, ज्याच्यामुळे डेथ होऊ शकते. विल गो वेट फॉर हिम, ही हॅज कम, विल रेकी फॉर दॅट, रोज येतो का, किती वाजता येतो, काय ते, आणि बरोबर त्याला मारेल. सो ही हॅज इंटेन्शन. That is mens rea. You know, everybody knows. In law, unless there is mens rea, criminal intention, there can't be no offense. आला त्याला मारलं. This is murder. This will come in 300. आता तुम्ही म्हणाल की इंटेन्शन मग 304(1) मध्ये पण आहे. If he has intention and knowledge. So what is to be seen from the evidence that this intention which is with the accused, that is at the spur of the moment, in the heat of anger and passion. That is how he had intention. समजा दोघांमध्ये भांडणं झाली, इतके चांगले मारामारी झाली, खूप त्याने मारलं, मारतो मी, मारतो हा. नो, दिस इज इन द हीट ऑफ पॅशन अँड अँगर. त्याने त्याच्या हातामध्ये काय सुरा होता तो घेतला आणि मारला. सो ही हॅड हिट because he had intention, but this intention was at the spur of the moment. He had no intention to commit his murder or to kill him, but he at the same time had also knowledge की असं सुरा जर मारला तर तो मरू पण शकतो. So his case will fall not for death or life, not for death, but will fall under life or 10 years. मग बाकी फॅक्टर्स will have to be taken into consideration. 10 years द्यायची, लाईफ का नाही द्यायची, तर दॅट इज अ होल थिंग. मॅडमनी परत बोलवलं तर आपण करू डिस्कस त्याच्यावर. नाव 304 पार्ट 2 मध्ये काय, ही हॅड नॉलेज बट नो इंटेन्शन. तुझ्याकडे आयपीसी कोण शिकवते? स्टाफ आय थिंक इज गेटिंग बोर्ड. नाही नाही होत. नो मॅडम बघा 200 आणि 2 कोण शिकवता तुम्ही? गुप्ता मॅडम शिकवता? नाही, त्यांचं लक्षच नाही. बरं एनिवे बघा 304 पार्ट 2. हॅलो, इज व्हेरी इम्पॉर्टंट व्हॉट वी आर सेइंग. 304 पार्ट 2 मध्ये काय, देशमुख मॅडम? 304 पार्ट 1 आय टोल्ड यू दॅट देअर हॅज टू बी इंटेन्शन, बट इट इज नॉट प्री प्लॅन्ड, कोल्ड ब्लडेड आपण ज्याला म्हणतो तो मर्डर. पण दिस ॲट द स्पोर ऑफ मुवमेंट, हीट ऑफ अँगर मध्ये तुम्हाला जे इंटेन्शन येतं आणि तुम्ही ऍक्ट करता, दॅट विल फॉर इन 1. अँड फॉर 2 यू हॅव नॉलेज बट यू हॅव नो इंटेन्शन. थिन लाईन ऑफ डिफरन्स. इन्सिडेंट्स द्यायचा तर सपोज एखाद्या टेलरकडे गेला. आता टेलरकडे कैची इज द मोस्ट अवेलेबल थिंग इन हिज शॉप. अँड इफ ॲट दॅट प्लेस त्या टेलरचं त्याचं काय समजा भांडण झालं, काय बोलचाल झाली कशाईवरून, त्याने ती कैची घेतली, त्याला मारली. तर आता काय, ही हॅड नॉलेज, ती मरू शकतो, बट ही हॅड नो इंटेन्शन. इंटेन्शन इज टू नॉट टू कॉज डेथ, दॅट वॉज टू जस्ट हिट इट. So this is how the case would fall. This is evaluation of evidence. So you can evaluate the evidence only on the basis of evidence which is in the court, not on the basis of statement recorded by police. 161 statements are used only for the purposes of contradiction and omission, not for corroboration. What is corroboration? जे लिहिलंय तसं सांगायचं. That is not the intention of lawmakers. त्याच्यातनं जे नाही सांगितलं किंवा जास्तीचं सांगितलं ते रेकॉर्डवर आणून तो कसं खोटं बोलतोय ते आणून मग त्याचा एव्हिडन्स इव्हॅल्युएट करायचा. दॅट इज हाऊ द लॉ इज टू बी कन्सिडर्ड. आणि त्याला म्हणतात इव्हॅल्युएशन ऑफ एव्हिडन्स. तेवढं माझ्या माहितीप्रमाणे. त्याच्यापेक्षा तुमच्यापैकी कोणाला जास्त माहित असेल नाही असू शकतं ना. अल्टिमेटली लॉ इज सच अ वास्ट सब्जेक्ट. यू कॅन इंटरप्रिट. दॅट इज व्हॉट आय सेड इन द बिगिनिंग. सिव्हिल मध्ये 1+1 कॅन बिकम 2 ओनली. क्रिमिनल मध्ये दिस कॅनॉट हॅपन. दॅट इज वाय बघा मी सांगितलं असंच तुम्हाला एका केसमध्ये की ज्यात डेथ सेंटेन्स झाली होती 9 आरोपांना. ती अपिलामध्ये दे वर अक्विटेड. नॉट इवन अप टू द सेंटेन्स ऑफ लाईफ दे वर ब्रॉट डाऊन, बट क्लिअर कट ॲक्विटेड. का की इथं 1+1 होत नाही. दिस इज हाऊ द वन कोर्ट अँड अदर कोर्ट कीप इव्हॅल्युएटिंग द एव्हिडन्स, इव्हॅल्युएटिंग द थिंग्स. सो आय थिंक दिस इज इनफ फॉर टुडे. खूप जास्त लेक्चर लंब केलं ना की मग विसरत जातो आपण. नाही की नाही. सुरुवातीला काय केलं तुम्ही सांगा बरं. व्हॉट आय स्टार्टेड विथ व्हॉट. हा लिटल लाउडर. हा हे केस बघा. मग आता कसं आतापर्यंत दे आर अटेंटिव्ह. आता पुढे डोंट स्ट्रेच देम. क्वेश्चन आन्सर्स we don't allow mentioning. काय काय क्वेश्चन any staff question? I would like to नाही. मी आता तेच सांगितलं. एंड ऑफ द डे व्हॉट यू हॅव टू इव्हॅल्युएट इज ऑन द बेसिस ऑफ एव्हिडन्स बिफोर द कोर्ट. एव्हिडन्स नाही म्हटलं तर काय मग ओपन अँड शट कन्व्हिक्शनचे होते आणि ॲक्विटेडचे पण. एव्हिडन्सच नसेल तर कोर्ट्स आर हेल्पलेस. देअर हँड्स आर. कोणती. हा राईट राईट राईट. हा नाही. जिथं एव्हिडन्सच नाही तिथं नाही घेता येणार. अल्टिमेटली यू कॅन बेस युअर जजमेंट ओनली ऑन द बेस ऑफ एव्हिडन्स. त्या कोकेनच्या केसमध्ये मी काय सांगितलं की इट वॉज अ व्हेरी गुड केस फॉर डिफेन्स. त्याचं जे होतं ऍक्टिव्हिटीज. पण त्यामध्ये होऊ शकते की दे मस्ट बी हँड इन ग्लोव्स टुगेदर पर्सर अँड पायलट. की तू कर कन्सिल. मी नेतो सिन्स आता 10 वर्षापासून मी येतो आहे. तू मला सगळे ओळखतात. गेलो चेक इन केली बॅगेज है ना. परंतु अगेन दॅट प्रिझम्पशन सेक्शन 54 ऑफ द NDPS ऍक्ट आहे. त्याच्यामध्ये प्रिझम्पशन आहे वेन देर इज अ कॉन्शियस पोझिशन. देर वॉज अ कॉन्शियस पोझिशन. सो देर वॉज नो क्वेश्चन ऑफ एनिथिंग. तसं अँटी करप्शन मध्ये पैसे जर खिशातून सापडले तर घेतलेच असं होत नाही. तुम्ही मान अशी केली म्हणजे हो म्हटलं की नाही म्हटलं. मग माझं बरोबर आहे का तुमचं. अच्छा माझं. त्याच्यामध्ये काय ना पैसे प्लॅन्टिंग काय होऊ शकतं. त्याच्या खिशात टाकले पैसे है ना. नियर रिकव्हरी ऑफ नोट्स डझंट से ही इज इन्व्हॉल्व इन टू दॅट. त्याच्यावर सुद्धा एक चांगलं लेक्चर ठेवता येईल. अँटी करप्शन लॉ, स्पेशल ऍक्ट इतकं आहे शिकण्यासारखं लॉ मध्ये. तुम्ही चांगलं करा लॉ. आणि डोंट से की पहिल्याच दिवशी तुम्हाला खूप केसेस झाल्या पाहिजे. वेटिंग पिरियड आहे. आय विल गिव्ह यू वन ॲडवाइस. नेव्हर जॉईन एनी फर्म. If you go to firm, you don't get chance to argue yourself. Simply you will go at the most before the court and say my senior is before some other court. Matter will be kept back or I mean be given date. Don't do that. Whenever juniors used to come, I used to say, no, no more adjournment. You start with the brief. The brief घेऊन नसतात. कारण त्यांना सिनियरने कधी brief दिली नसते. ते म्हणतात की go to court number so and so and ask for time or keep back the matter. आता किती वेळ keep back करणार ना? We also, when the first 5 matters, we are definitely not going to action. We make it specific note on the board itself. So those 5 matters, they come, they argue. Then when we proceed further, then they think now as if from 6 onwards we are free to give dates. But not, it is not that. And then as a junior from firm, I see, I am here for more than 10 years. I was judge. I see those who are asking for dates are even today asking for dates. So, त्यापेक्षा see a good lawyer and join them and work with him. Yes, any questions from staff? You are in the staff. Which subject you are in dealing with? Property. Yeah, this intellectual property, company law. No, I was also chairman for NCLT. That is also very good upcoming law. You people, there are so many youngsters I find appearing before me. IB code, insolvency in bankruptcy code, highly paid, big amounts are involved, and very less brain is to be used. Yeah, at this stage, yeah, it's a very new act enacted in 17, made applicable since 19, and thereafter COVID came. So 20, 21, 22, there was no much hearing in these cases, but the stakes involved there in IV code are so high. You must have heard that Anil Ambani's Reliance Capital that has admitted that is my order. He had obtained loan from 25 banks, and that was running into 30,000 CR, and not a single bank was coming ahead to recover the loan. See, all big persons, no bank will come behind them. You ask for a car loan, and if your one installment is not paid, 2 persons will come, 3, they will take your car with them. So in that, out of 25 banks, since nobody was recovering, so RBI stepped into their. So RBI came with a petition to get it admitted. That was 30,000 crores, 20,000 crores. My instructions are to my registry to not to list the matter which are less than 5,000 crores. Because we receive such instructions that matters in which high stakes are involved. Banks needs money, and when all this money is stuck, what can they do? And unfortunately, that studio here in your Raigad, ND Desai studio, that was unnecessarily hurriedly admitted. What was the amount involved was from 140 crore. This is how the things go. Yes. Yes, yes. Correct. Yes. Correct, correct. Yes, yeah, yeah.
But still the court asked us that whether the charges paid. So that time the dilemma comes that if somebody also a junior still the charge was already filed on the state of the case.
No, but then no, your only prayer is that you need permission to travel abroad. Yeah, so there is no question of even filing of charge sheet. So far. So even if it is not filed, you are in the judicial custody. And once your police custody ends, that is what I said. After 14 days, you are remanded to judicial custody, and thereafter you apply for bail. You are released on bail. Condition is imposed to not to travel abroad or to travel with the permission of the court. So court has to see whether there is possibility of his fleeing from justice.
But then my question is whether the we should put forward an application that charges to be paid. Honestly, that is a very long.
So that is what I am saying. You are on the point of charges. I am saying no stage is necessary for your application. Even if no charges are framed, you are seeking permission to go abroad. Maybe before filing of charge sheet also you can file. After filing of charge sheet, even during trial, if there is certain emergency, there is no such kind. It depends from court to court. Yes, yes, yes. When you know that he is not likely to flee, you can impose heavy surety. जामीनदार जो म्हणतात ना, you can impose two sureties. If they are unable to produce him, then in serious offences, even sureties can be taken into custody. If they are unable to repay the amount of surety, you can impose heavy this thing. But actually, yesterday you had that lecture on bail. Hmm. Bail is ultimately is not that to be considered on merits. You have to only see the prima facie involvement. At the end of the day, he may be acquitted, he may be convicted. So at this stage, you should not curtail anybody's liberty, which you otherwise cannot grant. Mr. Chavan used to appear before me. Yesterday he had come here. Who is here? Yeah, in 99 I was prestigious Thane. 99 December. Chalo then, let us be. Any more questions? Yes, madam. Ah, yes.
Ethical considerations and safeguards are in place to prevent the introduction of individual or unreliable evidence in the court. And how does the adequacy of evidence impact the fairness of the trial?
That is what we are seeing for last 35 minutes. We have discussed this. Evidence, examination in chief, cross-examination, contradictions, omissions, how they are brought on record. And from that, you have to say if it is true or wrong, false, if the witness is reliable or unreliable. Because if eyewitness is examined and if his evidence is full of contradictions, hmm, or if it is full of omissions, that is which is not stated to police, but he is making so many improvements stating in the court. So that witness is not to be unreliable eyewitness. And law has developed to such an extent that you should not rely upon the quantity of evidence, but the quality of it. एक eyewitness गया, if he is reliable, rely upon it. The 10 eyewitnesses and all of them are unreliable. Makes no sense. Then, no more boring. You are also from staff. Which subject you are teaching?
की मी माझी डिग्री कंप्लीट झाल्यावरती आय विल ऑल्सो गेट इन टू दिस आणि मी माझ्या आयुष्यात निदान एक क्रिमिनल केस तर नक्कीच लढणार. Criminal justice system is the theme for our lecture series, and in that lecture series today's lecture was indeed a lecture wherein we could see the entire justice system that happened from trial to the end, wherein sir तुम्ही सांगितलेलं कमिशन, ओमिशन, कॉन्ट्राडिक्शन ह्या सगळ्या कॉन्सेप्ट इन जनरल कॉन्सेप्ट आपल्याला माहिती आहेत. बरेच जणांनी त्यांची इंटर्नशिप सुरू केलेली आहे, बरेच जणांना इंटर्नशिप करायची इच्छा आहे, कुठेतरी शोधतायत. तिथे सरांनी सांगितलं तसं तुम्ही इंडिव्हिज्युअल ऍडव्होकेट कडे जाल त्यावेळेस तुम्ही काय काय फेस कराल, कुठल्या कुठल्या स्टेजेस येतील, या इतक्या सिंपल सरळ सोप्या पद्धती तुम्ही सांगितल्यात. नक्कीच हे शिकायला वर्ष लागतील. सुरुवातीला आपण सरांचं इंट्रोडक्शन वाचलं. इंट्रोडक्शन दॅट वॉज लाईक सर यू आर अन इन्स्पिरेशन. सरांनी त्यांच्या आयुष्यामध्ये हार्डली एखादी गोष्ट असेल जी राहिली असेल. सर हॅज बीन अन ऍडव्होकेट, अ पब्लिक प्रोसिक्युटर, लेक्चरर, देन अ सेशन्स कोर्ट जज, हायकोर्ट जज. सरांनी आता आपल्याला सांगितल्याप्रमाणे NCLT. सो जवळजवळ सगळे एरिया कव्हर केल्यावरती तुम्ही आम्हाला सांगितलं स्काय इज द लिमिट, की कायद्यामध्ये जेवढं कराल तेवढं कमी आहे, तुमची फक्त इच्छा असायला हवी. त्याच्यामुळे सर थँक्यू व्हेरी मच. सरांचं आणखीन एक मला सांगायला आवडेल, शेअर करायला आवडेल. मी जेव्हा सरांना इन्व्हाइट करायला फोन केला फॉर द इनॉग्रेशन ऑफ द सेशन, सरांनी समोरून सांगितलं इन्स्टेड ऑफ इनॉग्रेशन कॉल मी फॉर अ सेशन वेअर इन आय कॅन हॅव एन इंटरॅक्शन विथ द स्टुडंट्स. सरांची फार इच्छा होती की तिथे येऊन तुमच्या बरोबर हे सगळं शेअर करण्याची. सो फॉर दॅट रिझन सरांनी पर्पजफुली एक सेशन घेऊन पर्पजफुली हा टॉपिक घेतला. बिकॉज इट इज बीन सीन अँड ऑब्झर्व दॅट वर्षानुवर्षाची प्रॅक्टिस होते पण तरी सुद्धा काही लोक एका जागेवर अडकतात. त्याच्यामुळे हा एक सिन्सिअर प्रयत्न आणि नक्कीच सर दॅट वॉज सक्सेसफुल की आम्हाला सगळं म्हणजे मी स्वतः क्रिमिनल साईडला प्रॅक्टिस केलेली नाही. माझी जी काही प्रॅक्टिस झाली ती सिव्हिल मॅट्रिमोनियल या साईडला झाली. पण याच्यामध्ये आता मला खंत वाटते की मी माझ्या आयुष्यामध्ये क्रिमिनल साईड प्रॅक्टिस का नाही केली. सो थँक्यू व्हेरी मच सर फॉर कमिंग हिअर, शेअरिंग ऑल युअर एक्सपिरियन्सेस विथ आवर स्टुडंट्स आणि लुक फॉरवर्ड फॉर फर्दर मोर सेशन्स विथ यू. थँक्यू सर.
Thank you, ma'am. I invite Ms. Supriya Mishra, student of 4th year BLS LLB, to express her gratitude and deliver the vote of thanks.
Your question was there, no, madam, that you that Pradeep, he was under my was talking to okay. So he was doing so many pictures that time. So every day they were used of that problem. So I said, because of this case, why he should be treated for not really. I used to get it from the airport because you can ask and his case is still not finished. But he has done more than 10 pictures.
Thank you, Samruti. A very good afternoon to one and all present here. I, Supriya Mishra, Student Coordinator of Research Committee, on behalf of Janardan Bhagat, Shikshan Sanstha, Bhagubai Changu Thakur College-of-Law, and entire fraternity of the institution, as we bring curtains down on third day of this captivating lecture series, I extend my sincere gratitude to Janardan Bhagat Shikshan Sanstha to give us this opportunity to make this event such resounding success. As we all know that gratitude is a language of heart to show appreciation towards a person. But these words will be less for our today's guest of honor, Secretary of JBSP Sanstha, Dr. S.T. Gardes sir, Mrs. Varsha Prashant Thakur ma'am, for kindly gracing the event with their presence. On behalf of my institution, I extend my heartfelt of appreciation to our Chief Guest, Honorable Justice Pradeep Deshmukh sir, former Judge of Bombay High Court, who has spared his time from his busy schedule to grace this event. Today, we had an opportunity to hear your thoughtful session, sir, and this insight gained during the session will serve as beacon for our future endeavors. I especially mention to our respected principal, Mrs. Sanvi Deshmukh ma'am, for being the classmates that incited to do our best for today's event. An event like this cannot happen overnight. A wheel started rolling a weeks ago. It requires planning and bird eye for the details. With deep sense of appreciation, we thank to all our beloved and respectful professors and non-teaching staff. I'll also like to extend my vote of thanks to the people who have worked behind the scenes because of their meticulous efforts that has made this event possible and successful. Last but not the least, a big thank to each one of you for being so disciplined and good listeners. Let the knowledge which we have gained today fuel our journey forward. Thank you. Thank you, Supriya. Before concluding today's session, I would request everyone to stand for the